Hi, my name is Riley Maxwell,
I'm Josh Clark.
and today we are hosting our second episode of our Topic Knowledge series. We'll be talking to Anthony Trufanov, debate coach at Dartmouth and former NDT champ, who debated at GBN in high school, and we'll be discussing the topic this year and his new website. To start, I kind of wanted to ask you what was a meaningful round in college or a cool round in college that kind of might provide some insight onto how you had such a successful season in college.
Um, Thanks, and before I go into that, thank you all for having me. This podcast, wonderful idea. I'm so glad that you all are out here working to create more resources, to make more resources available for people who are looking to learn more about the topic, even if they aren't able to go to camp. Favorite round. So I don't know if this was my favorite round to be a part of, but I think that this is a good springboard and a good round to talk about for thinking about how one might strategize for a debate topic or for a tournament. And this is actually a pretty low-key one, like not a lot of people have asked me about it or anything. But so round 7 of our junior year NDT, we debated the team that we would ultimately end up facing in the finals of that tournament from Georgia. And this was really a debate where most of what was important and most of the important decisions that happened in that debate happened weeks before the tournament had started. Um, this was a team that was extremely good, as evidenced by the fact that they were in the finals. They were two incredibly talented debaters. But the way that they were preparing for that tournament was really heavily structured by some realities about how the topic had broken down over the course of the year. This was a topic that was incredibly large. If you want to get an idea of this, you can look up the executive power topic in college from 2018, 2019. The resolution was like 60 words long. There were like 6 different areas. One of them was like resolve change trade policy. It was enormous, right? And so as a 2N, if you're strategizing around this, you have to identify certain constraints that the topic imposes on affirmatives and really try to exploit those constraints that affirmatives have in common. And on this topic, one such constraint was the idea that you had to justify restricting executive power. You couldn't have the executive just change their own behavior by themselves. And the tricky part of this wasn't really the counterplan. And we'll talk about how there are some similarities between this and the IPR topic, but it was really easy to write a counterplan to just have the executive branch change their behavior to be more responsible. The trouble was with coming up with a net benefit. Usually people would use politics or elections or something like that. Those were kind of the low-hanging fruit ones. And Georgia in particular had become very consistent and very good at deploying politics as a net benefit to the executive self-restraint counterplan as a way of simplifying their negative prep process and really focusing in their work. So our idea was we're not going to write an app that is quote unquote good in any real sense of the word. We're going to write an app where if you open the 1AC and one of the first cards in the 1AC that you'll see is this Pinkerton 3 card about like nuclear war impacts to a cyber weapon civil war in the United States. It's like it's not a very good 1AC. What it is good at doing is being an affirmative that really messed with the way that politics had worked throughout the season. This affirmative was a literal Trump conspiracy theory. And most of the politics dissent that had been written on that year relied on Trump vetoing the plan and thus losing political capital because Trump would oppose restrictions on his authority. But because we had written an affirmative that was literally made up by him, basically, um, although there was some grain of truth to it, it doesn't really, but the core idea of it was we wrote an affirmative that Trump so thoroughly supported that it was very easy for us to win, that Trump would never veto the plan, that it would look like a compromise by him. It would look like a gesture towards reasonableness. It would look like him graciously accepting some restrictions on the executive. And we had all these fancy link turns to politics that by the end of the debate, we were never going to talk about the case by the end of the debate. And the affirmative was so small that in other respects it was so difficult to punish that Georgia basically was forced by the realities of how the topic was structured to march straight into our trap because realistically there was no way for them to have prepared a case neg. They just had to deploy their generic that we had developed an exploit around. So this one was really my favorite because just personally as a debater, I'm not that huge on the in-round speeches part. Like I just never really enjoyed that part that much. And the part that was really always fun for me was gaming out how a strategy could work before the round had even started, seeing if the research could support it, And I always found that part of debate very, very interesting.
And so you said that like there wasn't really any other out for them. I guess like did you think there was a potential chance they would try something else? Like some other diss out on the topic or
Well, as with any gamble, you're inherently playing the odds. If it's of course possible that they're going to break from their trend, and then that we would, be penalized for that. It's part of that is you have to think about, okay, what's the probability that that will happen? What are the ways in which that could happen? To what degree do those things reduce our probability of victory? And is the payoff of the expected outcome high enough? Like, are we so guaranteed to win if they go for politics that it's worth making all of these trade-offs? The one risk with this affirmative, because of how small it was, that we thought was quite real, was topicality, just because it was an extremely wonky affirmative. And if you look at my 2AC speech, so that this was an affirmative that was about restricting surveillance. The core topic disadvantage to this area was about terrorism. Um, and what this affirmative did was it made it so if you collect information in bulk that has a chance of collecting information on United States citizens, and another agency asks you to reveal a name that you have redacted through an automatic process that has been secreted because it's a US citizen name, before you reply by giving the agency that asks you the name, you have to ask your agency's general counsel to sign off on that request. So like about as nothing of an affirmative as it could possibly be, right? So
Super tiny.
we really were not worried about losing to the terrorism DA. Like
right.
we had some specific cards that were just like, this is a completely costless change that we could make. And so although this is a generic affirmative in that area, or although it's a generic argument in that area, you can see in the 2AC that I gave in that debate that I read like I think one card about terrorism. I spent maybe 30 seconds on the argument. What I did cover quite extensively was I think I spent like 2.5 minutes on T. And this was even though there were like 7 off-case positions that were read, right? We knew that T and the politics DA were basically the only things that we needed to talk about because politics was the net benefit to everything that mattered, and T was the only other out.
So I got to ask, who found this F?
McCaffrey. So
Jeffrey.
this was the idea was the ultimate production was a collaboration between us, but he found all of the core materials for it. Yeah, we had worked together in high school. He coaches at maybe still coaches at GBN. I'm actually not sure if he still is over there, but he's an incredible mind for finding an unorthodox perspective on an area.
Yeah, I'd heard the story from Lincoln's perspective, so I'm happy to hear it from yours.
Yeah.
All right. Well, maybe we can kind of move from this story to talking about the new topic. Truf, I know you have some thoughts about kind of how to approach a new topic broadly. Would you mind sharing some of those?
Yeah. So, and this is the reason I chose this story. I think you'll find that, broadly speaking, there are a couple of ways of looking at a topic, and they basically exist on a spectrum of how much you are adjusting for the fact that the realities of debate and debate strategy warp the way that the literature plays out in some ways. There are those who think that one should only follow the literature, that you should basically go to Google, you should search what the mainstream positions are, and those would roughly correspond to what the AF and the neg positions should be. There are also those, of course, who don't care about what the literature says at all, and they approach it purely from a debate game perspective. I think there's a time and a place for most of these different perspectives. So the example that I gave was probably more towards the debate game side of things than towards the literature side of things. But I wouldn't say that that was a conventional way of that I took, like that was an aberration in terms of how I approach thinking about the topic. And most of the time, I think people should not really be thinking about the topic this way. I think people will be more surprised to say that I don't think that the pure literature way is correct either. And so, well, what are the problems with that? One is the resolution doesn't always line up to exactly what the literature says. So the af and the neg ground is filtered through what is the exact wording of the resolution and how does that split the af from the neg. Another problem is just that in debate, there are certain things that we just don't care about that real people do care about. For example, in real life IPR discussions, there is quite a bit of weight given to the idea of appropriate recognition. So rather than purely a utilitarian discussion of what is the appropriate way to distribute economic incentives in an economy with respect to innovation or creativity, many people in IP care a lot about giving credit. They care a lot about the moral entitlement that an author has to control the use of their work. I think in real life, these are things that we should care about, but that you will have a hard time convincing really anybody in debate to bat an eye about, probably. Just because of how dominant the idea that we should purely be thinking in utilitarian terms tends to be in debate. So that's kind of issue number one, is we generally do want to follow the literature because that tends to be what leads us to the best cards, but we need to inflect the literature through the lens of some of the things that debate imposes such that those arguments are distorted a little bit. So that's issue number one. Issue number two is a lot of people go into a literature base, and the question that they ask themselves is, what are the arguments on the affirmative and what arguments are on the negative? And that's a good level one question, but you're not really preparing for a topic adequately unless you go a step beyond that and ask questions about, well, okay, we know what the arguments are, which ones are better than the others? And inevitably, that is a question that can only be answered in the terms of the metagame that will emerge as the debate season progresses. Arguments in debate are not objectively good or objectively bad. They are only good or bad insofar as the other team is willing, able, prepared to demonstrate that they are good or bad. And that might mean that some things that the literature doesn't take particularly seriously are artificially good because they exploit some weaknesses or patterns in negative preparation. And that was kind of the point of the story that I brought up, right? There are other things that are really good in the literature, but that are really weak to some core negative position that a lot of people have just really, really prepped out. And so they're just not that strategic. And different affirmatives have different strengths and weaknesses in those respects. And so those questions are really important to think about in assessing a topic as well. And then finally, there are positions that are strong in a vacuum, but that work better or worse as a component of a broader strategy. So one example of this is the sui generis counterplan. I've put it out, we'll talk about my website in a little bit, but I've put out an example of what a sui generis counterplan might look like. This is a counterplan that says, rather than protecting IPR under patent, copyright, or trademark, we should devise a totally new scheme that is tailor-made to the affirmative subject matter and to protect it using this bespoke approach. Pretty good in terms of what's the evidence supporting it. There's a lot of really, really strong cards for that idea. Much like executive self-restraint on the executive power topic, the trick is in generating the net benefit. And no camp has really hit the nail on the head with how I think that should be approached. So sui generis might be pretty good in a vacuum, but it's pretty weak if you can't come up with a disad that makes sense to make that a functional strategy as a whole.
So is there a nail to hit on the head? Like, have you come up with a good idea, or is it still kind of out of reach?
Well, I'm glad you asked. I think so. There's two different ways to write sui generis, and I talked about this on the article that I wrote about the strategy. And this is a perfect example of where it might make sense to distort the literature a little bit for the purposes of a debate strategy, right? So in real life, if you're thinking about protecting an area of intellectual property, let's take databases as an example. So the European Union has a sui generis right, intellectual property right for databases. The reason you need this is that copyright can't really protect databases because assembling a database is not a creative act. You are doing a lot of work, you're compiling a lot of information. It's a form of expression, but it's not a form of creative expression. The Supreme Court in Rural Telephone, in a case called Rural Telephone, said that this was a purely mechanical exercise. And they invalidated or kind of disclaimed the idea that one should protect intellectual products merely because the person assembling them, they had the so-called sweat of the brow, right? So just because they put in a lot of work doesn't mean it necessarily deserves protection. So the European Union was like, we accept that premise, but we still think that we need to protect this thing. So if not under copyright, then under the sui generis scheme, right? So that setup is all to say, so like if you are looking to design a bespoke solution to an area, there's two kind of genres of reasons that you might want to do that. One reason is that you want some kind of unique institutional features for that area. So an example of that might be in software, the pace of innovation is really fast. So it might make more sense to say, okay, patents give you an exclusivity period for like 20 years. Maybe the pace of innovation in software means 20 years is too long. And so we might want a shorter exclusivity period just to prevent people from gaining a monopoly that is excessively or inordinately long. We might care more about incremental innovation in the area of software than we do in another area. So sui generis scheme that shortens protection, there might be, we might care about those things. In debate, the implication of that is that you would be essentially writing a pick that says, we are changing the patent system in some very specific ways, and our net benefit is about those hyper-specific distinctions about the specific area that we are applying this thing to, right? You're essentially going for a pick out of some feature of the patent system. And for the reasons that I go into, this is a huge part of the literature on sui generis, but it is unlikely to work as a debate strategy. And the reason is the plan is never going to say something like this. And while in the literature, people take for granted that patent means exclusivity period of 20 years, it's not really the case that any system that can be characterized as a patent has to have an exclusivity period of 20 years. The counterplan could still be under the area of patent, right? The impact term is to the exclusivity term, not to calling it a patent. So what can we do instead? This is, I think, the better way of doing it, and it is to talk about the doctrinal implications of expanding the conceptual categories of patent, copyright, and trademark. So remember earlier I said the problem with protecting databases under copyright is the idea that databases are not produced with any creative input in mind. So a potential disadvantage to that area, to an affirmative that protected copyright or protected databases under copyright, would be to essentially say, if one were to do this, one would have to change the way that one thought about creativity as a requirement for obtaining copyright protection in a way that has much broader ramifications than just for databases. What other mechanical assembly processes might be implicated if we categorize a database as a copyrightable form of intellectual property? Might we be inadvertently setting the groundwork for expanding protection for example, the mechanical assembly of training data sets for artificial intelligence and for large language models? I'm just saying hypothetically, right? But the value of this approach is that if you focus on these precedents and you focus on ways in which expanding IPR dilutes the foundational conceptual categories behind IPR, you are simplifying your own prep work a little bit because you can think about affirmatives in terms of buckets, right? So is this an example of an affirmative that stretches the bounds of IPR because it changes what we mean by obviousness? Is it one that changes what we mean because, is it one that changes it because the industrial application standard for receiving a patent is something that this implicates? Are we messing with creativity? Are we saying that we need to think about something called facita, person having ordinary skill in the art? This is a legal doctrine for evaluating obviousness in the context of a patent claim, right? So all of these things, they're quite complicated. So I'm not surprised that nobody produced this as part of a starter set, but these are the real net benefits to sui generis. Because if you can prove that applying the name patent to a new area would result in distortions throughout patent doctrine as a whole, that creates a really good reason for applying a sui generis scheme, even if you don't think that the details of that scheme ought to be any different than how that protection would look under patent in this specific area. Now, all of that is a lot of work. And so I have a shortcut for people who are looking to not read about obviousness and distortion and precedent quite yet. And that is your good friend court clog. So lots of people have put out a court clog DA. Most people's link work, though, has focused on just proving that increased litigation arises from expanding people's ability to claim intellectual property. And that decides fine. I think it's not great. I think it has some link uniqueness problems and some uniqueness problems. I think it has some other strengths to compensate for those, particularly a really, really powerful ability to turn the case. But where this dissent is really going to shine is where neg teams are able to generate distinctions based on the strength of the link, depending on the extent of the affirmative's disruption to broader doctrine. i.e., if an egg is able to say this legal change has ripple effects throughout the entire patent system, and that's why it generates a bunch of litigation, that is a link story that is not only stronger, it is also one that can be avoided by protecting that area under a sui generis scheme.
And so with sui generis schemes, so has the US ever experimented with them before? And I guess like in what cases has the US used them? And is it just for that area to kind of like create like an exception?
There are two big ones, and I'm gonna butcher their names, but I'll tell you kind of what area that they cover. So the most cited one pertains to something called semiconductor masks. Um, I'm not entirely fluent on the technical details with this one, but the basic idea is there's a particular kind of when producing a semiconductor, you need to represent the blueprint for the semiconductor. You need to represent the design in a particular way. And in the 80s, when there was, a burgeoning semiconductor industry in the US, there was a question that was like, will this fit under copyright or patent? Because so one other idea about copyright and patent that is important is that patents protect ideas with industrial application that have been reduced to practice. Copyright does not protect ideas, it protects only expressions. So with a couple of areas, and most of the areas that you'll see a lot of sui generis literature about are like this, there is a question about which one of those areas is this something that falls into. So it's a particular blueprint. So the blueprint itself is an expression. So one would think that that is something that could be covered by copyright. But then, of course, it pertains to an industrial invention. So that's something that would suggest that it should be covered by patent. And there was a lot of uncertainty in the industry about which way courts would go in this respect. And by the way, if you're hearing this for the first time, you might be thinking, copywriting a blueprint, that seems like a very unintuitive way to protect an invention. You'll be surprised to hear, as I was, potentially, that software in the US is primarily protected through copyright because software is expression. You might think, oh, software is like, it's a thing that you invent, it's a thing that you come up with. No, because software is code and code is algorithms and algorithms are ideas, the US system has decided over the last however long that copyright is the appropriate form primarily to protect software, even though there are some patent aspects too. And anyway, in the semiconductor context, the way that Congress solved this problem was to come up with a special form of sui generis protection called, I think, the Semiconductor Chip Mask Protection Act or something, or Semiconductor Protection Act, something along those lines, where they basically came up with a sui generis form of protection for semiconductors. The other one that I'll mention is vehicle hull designs. This had to do with a similar blueprint type issue where the exact shape of the hull of boats was something that was in a similar kind of valley. Design in general, you'll read a lot about the fashion industry. There are questions about whether designs are protectable under copyright or whether they're protectable under patent. In the context of boats, Congress decided to step in and provide a bespoke form of protection as well. But so those are the kinds of areas where one would want to potentially intervene with a sui generis approach.
And if I understand right, the sui generis approach, like it's not like that was the name that they kind of instilled. It was just they wanted something separate from that. Uh and then in retrospect, they were labeled sui generis. So it's not like these were cognitively like, hey, we're going to do a sui generis approach. It was we need a separate approach, and then seeing that difference over time that got labeled that by the courts. Is that accurate?
I couldn't tell you what the authors of the legislation would have described what they were doing as. I can tell you that many people who were contemporaries of these debates would have described these approaches as sui generis. I should say sui generis is a Latin phrase meaning of its own kind. So as distinct from this is something that you're lumping into a broader category that is copyright, patent, or trademark. This is something that is of its own kind. It's not derived from those other things. And so it's kind of standing to the side on its own. So not sure what the Congress people would have said, but many people in academia who were writing about these debates described the trade-off as being, should we stick this in copyright, patent, or should we come up with a new thing?
And so the fact that it's kind of defined as its own category, like of its own kind, is the reason why like expanding patents might spill over to redefine what a patent means for other applications, but like increasing protection under like sui generis would not spill over to other forms. So just like where the disad comes into play.
That's
that
right.
okay?
That's right. And so one of the strengths of this literature base actually is that because there are so many historical instances of these debates, people are actually engaging in pretty granular discussions about what many of the intuitive permutation arguments that one would come up with against this could be. So one thing that is kind of implied in your question is, okay, well, if we think that this area is so special and we want to contain its spillover effect, why don't we just say, okay, like it's a patent, but it's a special patent. It's covered by some different requirements. It has its own rules. It's completely different than all the other kinds of patents, but we're still going to call it patent. And then that means our permutation doesn't sever and we don't link to our spillover DA. This was a proposal. People, in response to the semiconductor bill, in response to the vehicle hull bill, people said this and they said, like, just stick it in copyright. You're creating a lot of confusion for people. People are going to have no idea what this thing is. IP law is complicated enough. Let's just put this in the new category. Let's not create proliferating new. There was this concern that you know, once you open the floodgates, every single industry is going to show up and be like, oh, we're our own little special butterfly. The system doesn't protect our needs appropriately, give us our own special kind of protection. And there was this concern that it would open the floodgates for industrial protectionism. That in practice, that didn't really happen. But this was a real debate that played out in the context of those pieces of legislation. And so there is surprisingly strong evidence that says it's actually very difficult to contain doctrine in the way that is being described there. Judges are going to do what they're going to do. They're going to try to find precedents and analogies. Once you carve out an exception in one area, who's to say that you can't carve out an exception in another? That's another way that doctrinal spillover effects could occur like this. The virtue of this legislative sui generis approach is that you're basically leaving the structure, the skeleton of the framework up to Congress. And so courts are much less empowered by something like the counterplan to go out and say, oh, well, there's this exception over here. Maybe I can draw a similar analogy to some other area.
Well, in response to this for affirmatives, like I remember when you debated, you all helped put in vogue like reading disads against the state's counterplan. Would this be something like have spillover disads for the affirmative to read against this type of counterplan?
I don't think, I mean, the flip side of everything that I've said is that, you know, there are very strong pieces of evidence that say we should not design new sui generis approaches. There are real logistical costs to doing intellectual property protection this way. When we tended to read disads against counterplans, you know, in my ideal world, people would be doing this on every counterplan all the time. In practice, it's quite difficult just because, you know, with conditionality, it's quite challenging to make the case that the payoffs are worth the time investment most of the time. When we did it, it was like we can say a one card something nonsense about the con counterplan where we're not really saying anything substantive. So like whatever. With this counterplan, I think there's enough substantive to say that you don't need to do that. And the substantive impact turn that you would be getting into is just topic good bad, which I don't necessarily think the payoffs for that are as high or as asymmetric as saying con sets a precedent, which is something that the neg is much less likely to be deep on. But I haven't thought about that question in quite as much detail, so I would not be surprised if the way things shook out, I turned out to be wrong about that.
Okay. Well, that's great. I didn't foresee us going that deep into this counterplan, but I think that'll be super helpful because I think a lot of the people at camps are probably a little bit in the weeds for the application of this, and it sounds like this is a new way to generate some offense either from court clog or from those bucket DAs. Out of curiosity, before we kind of transition to talk about the resolution writ large, have you found any of these bucket disads net benefits?
Mm-hmm. They're all real. The reason I'm saying I'm not surprised that CAMS didn't produce them is because this topic is very hard. Like a high schooler will look at this resolution and the first thought that will pop into their mind is never going to be, oh, I need to write a precedent DA about the distortionary effects of changing the threshold for obviousness, right? And part of why I was able to stumble upon so many of them so organically is that many of the people arguing for sui generis approaches will do that in conjunction with saying the link argument to their DA. If you're looking for cards that are an example of how such a dissad might read, I would suggest starting your exploration in the software area, since that's the area where the most prolific writing has occurred. Many people writing about software and sui generis approaches will be couching their argument not only in the practical need for a specialized form of protection for software for innovation incentives, but also in a doctrinal argument about distorting the boundaries of copyright and patent.
And then before we move into the resolution, I just wanted to circle back real quick. So I guess like when you kind of look at a topic and think about what like delineates aff and neg ground, I guess do you start with like topicality research and think about what words in the resolution mean, or kind of like, I guess for the example, like this example, like what led you to finding the sui generis counterplan and realizing it was kind of like would be a core negative position?
Pretty much the first searches that I will ever do on any topic are topicality searches, because, as you said, the topic is the thing that determines the allocation of aff and neg ground. And so before you can say anything about what the best arguments on the topic are, you need to have some idea of what the topic means. And this is the aim that I'm attempting to achieve through my ongoing series, where I'm just attempting to explain different aspects of how the topic is laid out on my website. The particular sui generis example, the way that came up was that in Googling in searching for intellectual property protection definitions, I'm sure anybody who did this very quickly realized that the three listed in the topic are not all of the ones that are available, right? So probably one that fell out pretty quickly was you were like, oh, trade secrets is in there. So it's pretty weird that that's not listed in the topic. I think it actually makes a lot of conceptual sense that trade secrets isn't in there, which we can talk about if you would like. But that did lead me to think like, okay, so if trade secrets is not in there, what other kinds of intellectual property rights or what other things are out there that people are calling intellectual property rights protection, but that are not listed in the topic? The ones that I have come up with so far, and I will be producing fairly extensive counterplan work about each of them, are sui generis, a tort framework for governing unfair competition torts, and regulatory exclusivities. In addition to sui generis approaches, I think those are the like protection approaches that are philosophically different from the ones that are in the topic area, such that you could generate a compelling competition argument about them. And they all compete broadly on rights or property.
And then I guess transitioning into kind of like your takes on the resolution, do you think there is any other way of limiting out affirmatives via the resolution, whether it be like strength and protection or like domestic? Are there any other ways limiting apps besides like the sui generis counterplan and those disads?
It's tricky because if you start looking for scholarly work that defines the topic phrase, this topic's pretty different than the last couple of high school topics in that it actually means something. I guess last year's topic also meant something, but in the broad kind of in the last decade of high school topics, it's very abnormal for a topic to be sensible in any meaningful way. This is an exception to that. This is a topic phrase that actually means something. There are a lot of people writing about this. Conveniently, the comparative political science scholars who are looking at intellectual property rights schemes in lots of different places have put a lot of effort into coming up with ways to measure the strength or weakness of intellectual property protection, and they describe their efforts in those terms. The most cited paper on this issue is Jennart Park from 1997. They produced an index that is cited by thousands and thousands of follow-up papers, described by many as the industry standard for how one thinks about protection, intellectual property rights protection, strength or weakness. The bad news is that the Jennart Park Index includes basically everything that you could possibly imagine with respect to changing an IPR system. So it means something. What that thing means is quite expansive. I will give you a further piece of bad news, which is you might have read in some starter packs a topicality argument that is focused on excluding apps about enforcement. This is a very appealing thing for the neg to want to do, so I understand why this was written.
Are you talking
But
about the Mandel? Is that the Mandel stuff?
I think there was a separate. We can talk about Mandel in a second. I think that approach is like those cards are better, but I also don't think that they end up excluding all that much of anything that the F would really want to talk about. Um, I'm more there's a separate no enforcement section. It's some I don't remember the last name. I think it's from 21. But one of the things that you might notice if you read those cards closely is that they cite Janarton Park, and they look really good on first glance. They do the thing where it's like, oh, this thing is protection, this thing is enforcement. They appear to be drawing a clear line, but then the independent variable for their study is just the Janart Park index, and one of the things that feeds into the Janart Park index is a category that is called enforcement. So that raises the question, okay, so like how could this person, like presumably this person is smart, so like how could it be that they are so intent on excluding enforcement from their study, and yet they cite the Janart Park index, which includes enforcement as a variable for generating the index? The answer is, and the article could be way clearer about this, but what they mean by enforcement are actually very different things. So Janart Park have a bunch of things that are related to enforcement, but that are limited to the institutional structures of enforcement. So an example of this could be, let's say that you have a patent and you are going after someone for a patent infringement. One thing about the current system is that the burden of proof is on you to demonstrate that the product against which you are launching a suit contains the infringing technology. A proposal that is pretty common is to reverse the burden of proof on the premise that as the person who is initiating the lawsuit, you don't know how the product is designed. You need to go through a complicated discovery process to figure that out. The person you're suing knows how their product works, so theoretically it should be very cheap for them in terms of transaction costs to produce a demonstration that their product doesn't infringe. So one proposal is to invert the burden of proof. That's technically an enforcement issue, but it's an institutional one. Another example of that is the ease of receiving an injunction from a court, or the stage of the litigation process at which you can ask the court for an injunction against the allegedly infringing product. That's also an enforcement question, but again, an institutional one. So these are things that Janart Park thinks are enforcement. Why does Christianopoulou, thank you, Clark, think that these things are not enforcement? Well, what Christianopoulou means by enforcement are things that are proxies that affect the de facto outcomes of enforcement, but are not actually part of the institution. So for example, Janart Park make a point of excluding, like, we're not talking about the amount of corruption that exists in a court system, because corruption might make enforcement structurally much weaker, right? But that's very difficult to measure because that's not like a thing that you can point to in a book, in a law book, and say like this is a right. So what Christianopoulou means by enforcement that they're trying to exclude from protection is actually way narrower than it looks, in a way that I think actually makes that limit almost useless, because I don't think that any affirmative will be so explicitly effectually topical that merely asserting that affects topical affirmatives are not topical will get the neg very far in excluding them. All of that having been said, I do think that there is a different limit that the starter pack sets have underexplored to date that is potentially significantly more viable. And that is a limit based on the distinction between creating intellectual property rights and protecting them. My most recent post on topicality contains the word metaphysics in the title, and this is why. This kind of relies on a metaphysical difference in understanding what intellectual property and intellectual property rights are. Implicit behind a lot of these definitions that are very expansive is an understanding of those terms as, like, what we're talking about is the natural right. Like, there is a natural intellectual property right that exists and comes into being the moment an inventor or a creator undertakes an inventive or creative act. As soon as they produce something that we would understand as an intellectual property object, a right emerges under like Lockean understandings of property and labor, right? That then could either be protected or not protected, but which exists irrespective of what the legal system says about it. One could take a different approach and say, like, no, there are no natural intellectual property rights. Intellectual property rights are pragmatic legal monopoly instruments that are created by states. And until the state creates an intellectual property right, there's no such thing as an intellectual property right. There's no such thing as intellectual property. There's no such thing as property at all, right? It's something that we as civilizations invent. So it makes no sense to say that there is a pre-existing, pre-legal concept of intellectual property that could either be protected or not protected. If the neg establishes that concept, I think it's pretty easy to distinguish between protection of intellectual property and creation of intellectual property, or protection and creation of rights, I should have said. Like those concepts are, they come up in a lot of different areas of law. Two that I pointed to was the law of equitable estoppel is one where the distinction between creating and protecting a right comes up pretty frequently. There's a common maxim at equity that equitable estoppel is available to protect a right but can never create one. Another example is the equal protection clause. There's an extensive back and forth about what it means to protect. Does equal protection create new rights, or does it simply protect existing ones that the political system has already chosen to grant? There's lots of lit bases to draw on to distinguish between protection and creation. And I think that this is one where the AF really hasn't put in a lot of legwork, because I don't think that this assumption in these AF studies is particularly well examined. And I don't really think that AF has a typical appeal that could get them out of a lot of trouble in these areas, which is an appeal to legal precision, because none of these cards are legal. These are like political science studies that are occurring on a background of an ideological campaign to expand intellectual property rights globally through the vehicle of trade negotiations. So like there's an ideological background that informs why they chose that particular terminology, and that is something that neg teams should not treat as beyond contestation. What's the payoff of doing all this? You can exclude any affirmative that expands the IPR system to new patentable, copyrightable, or trademarkable subject matter. You can exclude, there's a lot of discussion about a thing called inter partes review. This is something that was created by the America Innovation Act that basically said a third party who is not related to the patent can show up to the PTO and say that patent is invalid, should not have been issued. It is obvious if you take into account the prior art. And then there will be an internal administrative review to figure out if that's true. And if it is, then the patent will be taken away. If a patent was issued in error, it does not correspond to any right that anybody has. So repealing IPR does not protect inter partes review. This is going to be very confusing over the course of this year. Repealing inter partes review does not protect any right that exists, because any patent that would have been revoked by IPR is one where the patent right didn't exist in the first place. Does that make sense? So there's a lot of potential payoffs to this kind of approach, I think. And this could actually be quite limiting in a way that is quite conceptually grounded.
And so then the I guess like the case list for that kind of T-interp is just like strengthening protection for existing a patentable subject, kind of.
That's right. This is another area where I think camps haven't really explored this literature base quite as much. But if you look at past debate community encounters with the concept of patent, you'll see a lot of mentions of something called patent hold up and patent hold out. These are economic terms that describe the inefficiencies in bargaining between two different parties that derive from the uncertainty inherent in the litigation process about infringement. So the idea is, if there's uncertainty, but you think that you are very likely to, so like, let's say there's a 50-50 chance based on uncertainty in litigation, whether or not you will be able to protect your patent right. If there is an infringer, it might be cheaper just to let them have it than to run the risk of going through the litigation process. And vice versa. If there is somebody suing you for a patent that, or for a product that you legally are allowed to make, it might be safer to just settle with them than to run the risk of uncertainty in the litigation process, right? This latter idea, which is called patent hold out, or hold up. So the patent hold up is the second one. That's what is described in the literature as patent trolls, or non-practicing entities, right? So because that more or less is related to an assessed probability of success or failure, or an assessed uncertainty about the outcomes of litigation, these are things that roughly map onto the the procedural aspects of how one would go about protecting or asserting a patent right or another kind of intellectual property right. And so that whole discussion of how do you balance the risk of hold up and hold out maps very cleanly onto a vision of the topic that concentrates on protection of rights that already exist rather than creating new ones.
And so, like, the implication of that T interpretation is that it excludes extending protection to new subjects. And then would the implication of like the question of whether or not protection includes enforcement? I know the Michigan starter packet had some definitions that implicate like agency. Could that potentially like create competitive agency counter or agent counterclaims? Like if the courts can only enforce but not affect like acquisition of intellectual property, like would the court's counterpoint then potentially be competitive?
So this is a much broader competition hornet's nest that is probably beyond the scope of our conversation here, just because I could ramble about this for hours. The thing that I will say about it is you're very likely to encounter a lot of counterplans on this topic with seemingly strongly worded competition cards that are not actually competition cards. Here's what I mean by that. It's pretty easy to find a card that is like the USPTO must issue a patent, or the USPTO must be the agency with which one registers a patent before one can enforce it in a court. You would think, potentially, if you like to be wrong, that creating a new agency that is not the USPTO would therefore be competitive because a new agency is not, it's the thing it's creating isn't patents.
Right.
That is wrong. The thing that the NEG must demonstrate in order to prove that a counterplan competes is that the word or concept with which they are competing cannot be the counterplan, rather than it is not currently the counterplan. Here's how that applies to the USPTO example. How many countries have a USPTO? Exactly one. It is the United States. It's right there in the name. Do those other countries not have patent systems? That would clearly be a ludicrous thing to say. And that's how you know that one can have a patent even if it was not issued by the USPTO, right?
Sounds like
Simple
a
test.
familiar
How does
issue
that
with
apply to
the
your
high
courts
school.
example? That's right.
Right.
How does this apply to your courts example? So the example that you gave is there's a lot of cards that say courts cannot create new intellectual property rights. They can only enforce existing ones. So what that is getting at is in the Constitution, in Article 1, Clause or Section 8, it says Congress is the one that will create intellectual property rights. Congress has acted and passed a series of statutes that represent the body of intellectual property law. Courts' role within the structure is to interpret what those pronouncements mean and to say how they apply. Now, if the counterplan, right, has the courts go out there and create a new thing in violation of the current intellectual property scheme, one could understand that to be something that works in two ways. Either one could say courts are just going rogue and are doing something illegal, right? I would argue that if we're looking at that, what we're looking at is courts illegally, but still increasing protection of intellectual property rights, right? Like they're doing it in a way that violates the constitutional framework, but like they're clearly doing it. The Constitution could have said something else. If what they're substantively doing is the exact same thing as the plan, and the plan is strengthening intellectual property rights, it makes no sense to say that just because it's courts and they're acting illegally, they're somehow doing a fundamentally different substantive thing. So that's one way to look at the counterplan. Another way to look at the counterplan, and this is certainly what would happen in real life, is the court would certainly make up some statutory basis for whatever it is you're saying, right? And really, that's what those cards that are what you're reading as competition cards are saying. Like they're saying all the protections come from the statutes. Well, the courts rule on the statutes all the time. It's not like the courts have no role in this scheme. They interpret the meaning and bounds of the statutory law. So if the courts stand up and say, hey, this is now protected, like that's something they've done a bunch of the time. They've grounded their argument for why it is protected under some interpretation of the statutory or constitutional scheme. And neither of those is competitive, but those are the same substantive action that is just being done by an abnormal process. This is quintessentially what we mean when we say the phrase normal means counterplan, right? And people are likely to be led astray by this because there's a lot of cards that look like competition cards. They say things like must, they say things like by definition. That's not real, like, they don't mean what they say. that's another instance in which the debate concepts that we're trying to apply are misaligned with the literature, and people are abusing the slippage in an intellectually dishonest way. Um, I'm not accusing people of bad faith or anything. I'm just saying like that is a thing that ends up not really being aligned with the authorial intent in those cases.
We definitely did that on the NATO topic with the Disca pick. So
I mean, you had to, like, there was nothing to say on that topic.
yeah.
Before we stop things, we want to kind of spend the last 10 minutes talking about your website and kind of your intent behind that, the philosophy behind it, and yeah, anything you'd like to share with us about this cool new resource.
I mean, so the website's called Debate Decoded. You can find it just by Googling it. I've also posted about it on the r/policy debate Reddit or in the high school policy debate Facebook group. What it essentially is a set of articles, drills, explainers, and files that pertain to the high school topic. The idea is, this is something I've wanted to do for a long time. Really, ever since COVID, I've had a general sense that the instructional setup in policy debate is not exactly, it's not as well set up to meet people's needs as I think it could be in a couple of ways. One is that there's a very big gulf between free resources and paid resources. So lots of people are out there doing great volunteer work and producing incredible stuff like this podcast. Like, these resources are awesome and people should make use of them. There's a very big gulf in between that and hiring a private coach, which can be very expensive. You're very likely to hire someone extremely young, which creates a lot of other problems that are quite endemic in debate. Deficit of adult responsibility. These things are recurring for a reason, and they're an outcome of really the economic reality that it is quite difficult to obtain paid coaching experience in an event where the amount of specialized information you need to know to compete at the national level is just truly mind-boggling. My goal is to step into that and to create kind of a middle ground. The files, the resources, everything that I'm putting on this website are things that, in past years, I have sold to private schools for individual use for quite a bit more than I'm charging people on this website. My hope is that I can sustain and justify the amount of output that I am putting into this by spreading the wealth and having lots of people give me a little bit. And hopefully that means that lots of people can get access to the kinds of resources that would previously have only been available to a few. And along the way, I hope to be able to produce a lot of resources that are just for free and public use as well. So that's kind of the motivating impetus behind this. There's a couple of files that are up there right now that I think people will find pretty useful. So there's a sui generis file. There's a bunch of drills that you can do to practice deploying that file in a debate. There's a process counter plan that I'm quite happy with. It's based off of an argument that we were going to win the personhood NDT with if we ever encountered an Emory or a Michigan in the finals. So I think I'm quite happy with the caliber of that file. As well as, upcoming, you'll see some T work, you'll see some of these specific area spillover DAs that we talked about over the course of this discussion, impact work, all sorts of things. Check it out. I hope you find it helpful.
Good. Yeah. If anyone hasn't checked it out, it's Debate Decoded. There are different plans. So like if you can just put your email in and you can get access to free articles and interaction. There's a $3 plan for some limited access to the website, and then a $5 per month plan for not. I mean, for a year, that's $60. That's if you I know if I take my family out to eat, I spend more than $60. So it's definitely a far cry from what it would cost to bring one coach to one tournament, which can be anywhere from $400 to $1,000. So it's definitely way on the lower end of costs. In fact, it almost seems pretty free. Do you have any plans on working with institutions or allowing institutions to sign up for a nominal fee or something like that?
Yeah, so if you're listening and you're associated with a school, and you want to sign up your entire debate team, I've done that with a couple of schools. I've given people half off, which makes the price point even more accessible. I've worked with a couple of camps that wanted to use some of the instructional materials that I've created. And I should also say, and this is important, if you know, we're talking about these amounts like they are trivial, you know, we want to expand access as much as possible. If the numbers that we're talking about are outside of your range, you should please feel free to reach out to me, explain your situation. I will give you access. If $5 a month is financially inaccessible to you, I will give you the resource. You know, I want my work to be valued. I want to, make this contribution be one that is sustainable, but that's something that I also want to balance with people having access to it if this is something that would be helpful.
Awesome. Yeah, anyone who's putting their time and efforts into something like this, and especially how generous you're being with that, it's much appreciated. Well, I would say nearly every coach is giving, you know, giving more time than they're being paid for, but
For
doing
sure.
all of this extra work just to be able to benefit the entire community as opposed to just for to help one team do better. I think it's a noble enterprise, sir.
Appreciate the kind words. I will say, like, I think a lot of coaches as they grow older tend to leave debate because they find themselves less and less driven by the competitive motive. They find themselves less and less rewarded by coaching a high schooler to attain some level of success at a tournament. And like, I, I very much understand that. That's something that I certainly feel less acutely now than I did when I was 19 years old. Um, many people move on to other things. I love debate more than anything. And so I would like to find a way to keep my motivation sustainable. And this is how I've chosen to do that. We'll see how it pans out. Hope it's helpful.
And that concludes our second episode of Topic Knowledge. We really appreciate you talking to us today and your work for the high school community through this website and everything else you've done. Feel free to reach out to us with any questions or inquiries at policydebatecentral@gmail.com. See you next time.